some concession on liability and causation.
Objection, speculation.
Speculation.
Well, so
What's
I'm
the box?
so
That's coming next?
so hold on. So we don't have anyone in the box yet.
169 Christopher Wren versus AffinityLifestyles.com Inc.
Go ahead and state your appearances, my left.
Will Kemp for Plaintiffs.
Theodore Parker for Plaintiffs.
Good afternoon, Your Honor. Eric Pepperman for Plaintiffs.
Good afternoon, Your Honor. Ariana Reed for the Carrier Plaintiffs.
Good afternoon, Your Honor. Joel Odou, Matthew Kaufman, Eric Freeman on behalf of the real water defendants.
Hi, Your Honor. Dawn Davis and Chad Beers for Milwaukee.
Good afternoon. All right. So you may know this. I don't have a law clerk this afternoon, so you may have to bear with me a little more than you usually do. But I think I'd like to start with the MSJ issue. I think the question posed was, the order on specific and/or general causation. I did have an opportunity to review, or re-review, I guess.
Judge,
Oh, go ahead.
we've been engaged in some discussions about various matters.
Okay.
And we think it would behoove the parties in the court probably to kick everything having to do with Milwaukee to
523.
523. Yeah.
Okay. Totally fine. So with that, what else do we have still pending today then?
Your Honor, we only have one other motion, and I think Mr. Kemp and Mr. Fears were also including the email I sent to Your Honor this morning, asking that the motion to strike Milwaukee's answer be moved to the 23rd. Did you see that email, Your Honor? This was short. I sent it to your of course, your JEA.
Okay. So the answer is no, I didn't see it, and it may or may not have gotten lost somewhere, but that's fine.
I just didn't want you to have to, you probably already prepared for it, but I didn't want you to do any extra preparation. So.
No, that's fine. So, do we have anything?
Only one thing left, Your Honor.
Okay.
And I wish we could report that Real Water and plaintiffs are working on a resolution at this point, but at this point we can't. You know, the hope is always there, but
that's okay.
And Your Honor, I thought it better to keep this one on as opposed to waiting until the 23rd, because this may take a little bit of time if the court doesn't mind. Also.
So which one am I looking at?
This is plaintiff's motion to strike Real Waters.
Oh, okay. Bear with me a second. Let me clear the ones we're not doing. Just slide it. That's okay. Thanks. A small biter. Okay, so this is yeah. Before you dove in anymore, so this is plaintiff's motion to strike Real Water's answer. Is that the one?
That is correct, Your Honor.
Okay. Do you want to know what I'm inclined to do?
Your Honor, not yet. I do not, because what I request may change the court's inclination.
Okay.
So I'd like you to keep it a secret.
Okay, so yeah, we are vacating a lot, but that means we have one, and so if you want 15 minutes in your opening, that's fine. But you did scare me a little when you said something about a long time.
Well, it depends on what you consider long.
And Your Honor, I'm sorry to interrupt, but I believe that you may be muted for the people on Zoom.
I unmuted.
Looks like we're not needed anymore, I guess. I literally have never seen that before.
This way. So I gotta know some of the tricks.
Wow.
There's a few of them. So you know, I'm using all of the everything you have here, all of the furniture. All right. Your Honor, so let me see if I can frame this the way I would like to, and hopefully it would be better received or received well from the court. I wanted the court to consider this motion first under, and I'm sure the court is familiar with the Young-Ribeiro factors. Both I discussed it, Mr. Odou's firm discussed those factors. I want this court to consider the Bahena versus Goodyear case.
So I'm familiar with that one too.
Perfect. That's a 2010 case, Your Honor. And the reason I want the court to, I would say focus, I was going to use the word fixate, but focus on that case and the Supreme Court's determination in that case, because that case specifically involved a data dump. That's how it's described. You've heard the term before. And this case, I would say, would make Bahena Goodyear look like the difference between an 8th grade vocabulary and someone graduating from Harvard in English. That case involved, in terms of the numbers of documents, significantly less than the documents we're speaking of here. And one thing I will say out front, Your Honor, first, I don't relish bringing this type of motion. I've only brought a few because I think the standard is clear. I think the factors are very clear, and you have to hit the factors to warrant striking. And I've known Mr. Odou for many years, and I've reviewed, just like I'm sure the court did, his opposition, and I take Mr. Odou at his word. And for that reason, Your Honor, I'm asking the court, I'm not going to ask the court to strike his answer. I want to say that up front. I think I told Mr. Odou that on the phone. If I didn't, maybe I intimated towards that. But I will tell you that I've tried to find another way, another form of relief, Your Honor. So let me start there, and I want the court to consider Bahena. I don't know if you have Bahena available to you, Your Honor, but
yeah, bear with me just a second. I thought I had it saved on my internal kind of database, but apparently I don't. So let me
take
pull
your
it
time.
up. Yeah, so it's a second. Okay.
Got it, Your Honor?
Mm-hmm.
And if you could turn to pages 253, 254.
1 second. Okay.
So, Your Honor, in this case, and we mentioned Bahena in our motion, page 10. In this case, 2021, the case is filed. 2021, actually September 29th, 2021. I'm gonna give the court some dates that may not be included in the motion practice, but they're dates that are pertinent to the case and pertinent to this argument, John. So September 29th, 2021 is the first special master hearing that I believe addressed this issue. I believe it may be even the first special master hearing in front of Special Master Floyd Hale. And we have special master hearings starting that early, going all the way to January 20th, 2023 for purposes of this discussion, Your Honor, that deal with real water producing documents. Now, if I were to accept, if the court were to accept Mr. Odou's opposition on its face, Mr. Odou makes certain statements on pages 5, 6, 7, and 8 of his opposition. That's his affidavit, John. And if we were to start at page 6 of his opposition, paragraph 17, Mr. Odou says that generally these materials, including the documents pulled from electronic devices, were produced in 2023. So when I first read this, I said, okay, when in 2023? Because I know in January 20th, 2023, in front of the Special Master Hale, Mr. Odou indicated to Mr. Hale, and I have it in front of me, that the gentleman at Holpucks, Holpucks statement was to me that it's a lot. This I'm reading from lines 22 and 23 of the special master transcript, Your Honor.
So let me pause you because I think you mentioned this, but I want to make sure that I heard. So you mentioned something to the effect of and I apologize because I'm not going to be able to quote you, but some of this may or may not be in the briefs. So
just the dates, Your Honor, the dates of these special master hearings.
So where you've got pulled up somewhere or something.
I do, Your Honor. I actually have them on my iPad, although I'm not very technically savvy. I do have the ability to bring it up. So I'm actually reading from it. I don't think that this is something that Mr. Odou will contest. These are his words that I'm actually.
Well,
but you don't have them in front of you.
As you probably know, I do like to follow along and I do try to read. So is this one of those things that you have on your iPad, but I don't have on my paper?
That is correct. You don't have this, Your Honor. This actually preceded me and my involvement in this case.
So why don't I have it though in my papers then? Because you put me in this difficult position when you know, this is a lot.
It is, Your Honor.
And you know, you're apparently relying at least in part on stuff that's not in front of me right now.
And Your Honor, I can do it two ways. I don't have to use it. I think this is going to be helpful.
So I would say stick with.
I'll stick with the bleed.
Stick with what I have in front of me.
No worries, Your Honor. I can do that. All right. So, Your Honor, the point is, in all of these special master hearings, Mr. Odou continued indicating that eventually these documents would be produced. So when I looked at paragraph 17 of his opposition, which I hopefully you have that in front of you.
Yeah.
I wanted to tie that to sometime in 2023. So then if you go to page 12 of his opposition, Your Honor, page 12, line 12. That's when he gives us some clarity. It says the end of September 2023. Now I want the court, do you see it, Your Honor?
Yeah.
Okay, perfect. So I want the court to understand that this case started in 2021, special master hearing, September 29, 2021. The first production of documents, October of 2021. And at the end of 2023, we still do not have all of the documents. So I want the court to consider that. So now we have at least a period of time of over almost 2 years, year and a half, where the documents that should have been produced have not been produced for plaintiffs to be able to access and actually make use of those documents for their experts, for depositions, all of those things. Now, in our motion, Your Honor, just to give you some more context here, we actually point out the discovery dates and deadlines in this case. And I don't believe that there's any argument from Mr. Odou on that point. And if you look to our motion, you go to page 7, paragraph 15. It indicates here that the discovery cutoff was April 1st. This is page 7, lines 10 through 13.
Okay.
See, the discovery cutoff is April 1st, 2024. Initial expert disclosures, February 5th. Rebuttal, March 1st, 2023. So Mr. Odou and I happened to be in trial in January of 2024 and through, I think, January 16th through the middle of February 2024. And in January of 2024, and Your Honor, I have an affidavit that I brought with me. This is something you did not have, but I brought copies of this. And I sent last night this declaration from Kelly. I said Gates, I'm assuming that's how it's pronounced, from Mr. Kemp's office. And I sent a copy to Mr. Odou last night. As soon as I got it, And I also called Mr. Odou this morning to make sure he received it and had a chance to review it. Mr. Odou said he did, and that he was not opposing me using it for today's argument.
Okay.
So may I approach Your Honor with a copy? Counsel? You sure?
No, you can come on.
Okay. I always give a look to the market.
No, that's probably wise, just in case.
Sure, why not? Thanks.
Thanks.
Thanks, Teddy.
You're welcome. So, Ms. Gates, Your Honor, in this, and I'm gonna give you a second, Your Honor, take a look at it.
Okay.
So, Your Honor, on January 8, 2024, Ms. Gates received 2 external hard drives from HOLO. And based upon her declaration, Your Honor, which based upon my conversation with Mr. Odou, he's not, I believe, contesting the statements in this affidavit. Those HOLO hard drives, or those hard drives, were not searchable. And certainly the documents, there was no index of those documents that would allow us to find documents to how we wanted to proceed in this case, or simply documents that are relevant to this case, be it the plaintiff's claims or the defendant's defenses. It was simply could not be done, Your Honor. That's just the truth of it all. And she actually spoke also to Mr. Holpuck, and that's the person that Mr. Odou referenced in discussion with the special master. And Mr. Odou actually says in his statement how much time it would take to go through these documents. And I would have the court take a look at page 7 of Mr. Odou's opposition, paragraph 24.
Okay.
All right. Paragraph 24, Mr. Odou says, because of the volume of materials produced from these 2024 searches, the limited staffing available to my firm due to the overlapping discovery schedules of the cases and the trials, redactions, and personal information uncovered by these 2024 searches was not completed until April 1st, 2024. Now, Your Honor, you know that's the close of discovery. You also know, based upon Ms. Gates's declaration, if you go to the second page, paragraph 7 of Ms. Gates' declaration, it says, on April 1st, 2024, the date of close of discovery in the consolidated Wren matter, Rio Water served the 20th supplement list of witnesses and production of documents pursuant to 16.1, Your Honor. 589-page index. The index itself is 598 pages, Your Honor. And what I would say to Your Honor, here is, just to give the court some idea of what we're talking about. This one binder is their 20th supplement. This is the index. Just to give the court an idea of what we received on April 1st, which based upon Ms. Gates's declaration, we still didn't have access until April 2nd, the day after, because it still was not, we didn't have access because HOLO wouldn't give us access until we got access relief, or we got confirmed access from Rio Water. And that's paragraph 8, Your Honor, last couple of sentences. So we don't have access until April 2nd. Now, in between January and April, and Mr. Odou confirms this, we had several conversations. Mr. Odou and I, our conversations heated up because during the Hunwartson trial, Your Honor, documents were discovered that Terrible Herbst produced during trial, which led to a discovery sanction against Terrible Herbst, that mentioned Rio Water's employees, the wife of the owner, the president, Amy Jones, who's also an officer. Those came out during trial. And so I turned to Mr. Odou, not literally, but within days, say, Mr. Odou, these should have been produced by Rio Water because they're Rio Water documents. Mr. Odou said he didn't see them. or he would have produced them. We go back and forth trying to find them. I will tell you, Your Honor, I have searched this index and we can't find that document identified in the index. Again, this is all after the discovery cutoff. So while Real Water may have produced the documents to Holo, and Holo may have created hard drives, those hard drives were in no way searchable. We couldn't do anything with them. And the first time we had access to do something with them was the day after the discovery. And this is the first time we have an index. Now, based on Bahena Goodyear, a data dump like that does not work. It does not comply with Rule 16.1. It simply doesn't. The other thing I want to show you that's really concerning about this, in my opinion, data dump, this is 16,071 pages that Mr. Odou, and I'll give credit to Mr. Odou, he said, Teddy, these were documents that were searchable. We had to send the search terms to Holo, but they were a part of those hard drives. I said, well, now I understand where you're coming from, Joel, and that's why I'm not asking the court to strike the answer. But that's still not complying with the rule and is not compliant with the Nevada Supreme Court's decision in the Bahena Goodyear case. The other thing I wanted to point out to Your Honor, and I want Your Honor to consider just how unreliable I think this disclosure is. This is a page from that 21st. Sure. The 20th supplement. This is a page from the index that Mr. Odou provided us.
This is one of the.
Just one page. You know my approach?
Sure.
Thanks. Yeah. Your Honor, I want you to take a look at the second item on this list. This is page 9 out of 589.
Mm-hmm.
It says here, email regarding hydrazine. The date, February 26, 2018, 12:50 p.m. Now, if that document exists, Your Honor, that means that every defense offered up till now, prior to some concession on liability and causation.
Objection, speculation.
Speculation.
Well, so
That's coming next?
So hold on. So we don't have anyone in the box yet. Well,
I didn't create the document.
Hold on one second. I know I talk slow and I'm trying to process an awful lot of information right now that I haven't seen, so bear with me.
Yes, Your
Honor. You guys. Can you hear me okay?
Yes, Your Honor.
And you?
Yes, Your Honor, I apologize.
Okay, so maybe I'll need to lean forward a little into the microphone, but I fully acknowledge I speak super slowly. I try and choose my words carefully. Part of that's just me naturally how I talk. But we're not in trial right now. So, objections in a hearing are a little humorous. I will acknowledge, however, as I've probably already indicated, but to be clear, again, Mr. Parker, you make it super difficult for me when I try and prepare and read things and review things and, and so, for example, while you're talking about all this stuff that happened on April 1st and April 2nd, one of my things I look at is, okay, well, did this happen did it happen before or after the motions filed? So while you've been talking, I look in the motions filed. Like you, I'm going to double check because I think I remember the date, but yeah. Motion filed April 9, 4:16 p.m. So we've got an awful lot of stuff that you're bringing up. If it happened on April 1st and April 2nd, and it's not in your motion, super hard for me to deal with. And so I can somewhat understand somebody making an objection, maybe not as to speculation, but I mean, but we're 20 minutes almost into your argument. So you've got 5 more minutes to tell me what you're pointing out, what you want, et cetera, and then we're gonna hear from Mr. Odou.
Sounds great, Your Honor. So I pointed this document out, Your Honor, and the actual document referenced in what I just gave you, Your Honor, the bait stamps. That document, which I'm giving to Mr. Odou right now, Your Honor, if I could approach.
We're going to object. We haven't seen this document before. He can't start introducing new things in this motion.
Well, hold on. So choose your words carefully, which is part of why I speak slowly. But I think that what I have in front of me right now, before I get the next paper, but I think what I have in front of me is page 9 of 589 of your index, right?
And Mr. Parker wants to hand you a document that I have not seen before that is not attached to any motion.
Well, but I mean, this is from your production.
He is the indexes in the production. They filed the motion. They didn't attach a single exhibit. Now they want to show you a document from that production. They could have put that in their motion and I could have responded to it in my opposition. I don't know why I'm seeing this document for the first time in court.
Well, so I think I've already kind of, I mean, you'll get your turn, certainly. But when you say I haven't seen this document, which is the first thing you said, I'm not sure that's factually accurate or not. It's from your own production.
This document has never been placed before the court until right now. There's an index that's coded by the person who coded the index that used the word hydrazine. I don't know if it says hydrazine on this document or not. I haven't seen it before. So that's my first problem. The court hasn't seen it before. That's my second problem. It's not attached to the motion. I'm not seeing anything about hydrazine in it. But again, that goes to the fact that plaintiff has offered this for speculative purpose without the foundation of providing the support that the document type in the index is a coding. That was a search coding put there by Hollow when they searched for these documents. The fact that
okay, I'm good.
The index.
So hold on. Okay.
Who knows?
Both. I'm going to take a little bit of a break. I thought the day would go differently. So when I come back, we're going to go back to Mr. Parker. You've got 5 more minutes. Mr. Odou, you'll have your opportunity to respond. I tried to make myself a little clear, but you know, sometimes when I choose words carefully, maybe it's not super clear, but I'm not a fan of bringing in a bunch of stuff that's not in front of me and has not been able to be responded by or isn't in your motion. That puts the other side. There's a little thing called due process. Notice an opportunity to be heard. That's very important to me. You know, so that's the other side, let alone me trying to prepare, put an awful lot of time into this. And I'm not a fan of, you know, surprise, surprise. Having said that, I'm also, you know, we deal in words and words are important. And so when somebody says, I haven't seen this, period. Like, well, is it in your document production or not? I think I'm looking at a page from your index of documents. It supposedly has a bait stamp of real water number, blah, blah, blah. Well, if you haven't seen it, that may be on you or maybe on your team overall. So I'm going to take a short break and we'll be back with 5 minutes and go from there.
Thank you.
Okay.
Your Honor, I apologize for any interruptions I caused. I didn't mean to, and to the extent I did, I apologize.
Okay.
The only other document, Your Honor, I was referring to before Mr. Odou began discussing his concerns was the one I've already given, I believe, to the defendants. May I approach, Your Honor?
I'll take a copy, sure.
Thank you. It's very short.
Thanks.
Thank you, Your Honor. This document does not appear to be the document referenced on this index. And so when I saw this document, out of the 16,071 documents referenced in this 20th supplement on April 1st, Your Honor, I agree with Mr. Odou that it takes weeks, if not months, to go through it. And I wanted to start with that because that hopefully it addresses why we didn't have the answer or have an understanding of the documents right after April 1st or April 2nd. So this document with the bait stamp numbers identified on this index don't mention hydrazine. Now, when we were looking at other documents and pulling them, they seem to match at least a couple we checked, but this one did not, which tells me I have a concern. The other thing I wanted to point out, and Mr. Odou would remember this, when this issue came up, and this is discussed in our reply brief, terrible herbs documents were discovered during trial in Hudwardson, and Real Water had not produced them. I go to Mr. Odou, I said, listen, you got to find these documents. They should have been in your production. Your Honor, we cannot, and we've checked this 598-page index. We can't find that document, the terrible herbs document in here. Now, perhaps I missed it, or perhaps Mr. Kemp's office missed it, but we had lawyers, we have paralegals, we have a lot of people searching, and we can't find these documents. So if I give every benefit, Your Honor, which I'm doing, and I have no problem with the court giving every benefit to Mr. Odou's declaration, it still doesn't change what Mr. Odou has said, that it would take weeks or a lengthy amount of time to go through it. Our paralegal says it would take weeks, if not months, to go through it. And we didn't have weeks or months because all of the depositions are done. All of the expert reports are done. They were required by February and March, initial and rebuttal. And none of these documents could be used in preparation for those reports. And that's not what the discovery says should be done. It's supposed to be orderly, it's supposed to be timely. You can't wait to 3 years virtually to produce an index that still can't be adequately searched. That does not work under the Bahena versus Goodyear case. Finally, Your Honor, when I consider everything that has happened and how it's affected the plaintiff's case under Young versus Ribeiro, we're not asking for it to be struck, because I don't believe that Mr. Odou did something willfully. His client went through bankruptcy, and perhaps they just threw all the documents, in boxes, and eventually Holo got them. But, Your Honor, there should be a consequence because it's against the rules. It's against the Nevada Supreme Court decision in terms of Rule 16.1, and the plaintiff's case should not be prejudiced without the jury knowing why. We should get an instruction, Your Honor, and the cost involved in all of this, Your Honor, has been extensive. And so I would also ask that the cost related to this motion and all the work we were trying to do.
I'm gonna have to pause you because I need
I got some extras, Your Honor.
No, yeah, I do too. Hold on 1 second.
Yes, Your Honor.
So last note I had is you want an instruction, and then I wrote that and I didn't hear that.
And the cost related, Your Honor, the amount of money we've had to spend bringing the motion, trying to go through what we can go through, Your Honor. Even Mr. Odou's declaration supports how much effort it takes just to try to get through these documents.
So what type of instruction?
Your Honor, we'd like an irrebuttable presumption that the plaintiff's case has been prejudiced by Real Water's failure to disclose documents, their withholding of documents, potentially their destruction of documents, and then the untimely disclosure of documents. And I think that's all fair given the dates that we're dealing with. I think that that's certainly the least harm that we could, the least sanction that I can think of given the circumstances, Your Honor.
Well, thank you very much.
Thank you, Your Honor. One other thing I'll do for the benefit of Real Water, Your Honor.
Out of the kindness of your heart.
Absolutely, Your Honor. If Mr. Odou would like more time to respond, given the 3 documents, the affidavit and his own, Real Water's own 20th supplement, and the 1 document, which was a Real Water document, which I gave the court, which has a bait stamp of Real Water on it. If he'd like some more time to brief it, I have no objection.
Thank you.
Thank you, Your Honor.
Mr. Odou.
Thank you, Your Honor. I'll let Mr. Parker.
Oh, or Mr. Parker.
Whomever.
I'm just gonna move a lot of stuff. Right?
No worries.
Thank you, sir. Your Honor, I want to apologize for interrupting. Sometimes it's very hard to go second and not speak up when you are frustrated. And I'm frustrated because the rules for practice in the 8th Judicial District require us to meet and confer and resolve some of these issues. And that was not adequately done here, and I apologize for that. I certainly take my share of blame for failing to communicate, because clearly I didn't explain how these documents came to be to Mr. Parker's satisfaction. We appear to be talking past each other. We're still talking past each other, and I apologize for that as well. Your Honor, it's probably too late to ask the court for your questions or inclination.
So, I mean, yeah, I'm probably not inclined to tell you what I was inclined to do. I don't know that that's changed or not in all candor, but questions I may have some as you continue, but not at this point. Not at this moment.
Thank you very much, Your Honor. I'm going to start at the beginning of my affidavit, and I would ask JP if you will pull up our motion and just start at page 1. And my affidavit starts at page 4. If he could have control over it. If we would go to page 4, please. And Your Honor, before I walk through my affidavit, because I think that's where there's a misunderstanding here, I would note that attached to plaintiff's motion were no documents responsive to the issues before the court. There were no relevant exhibits attached. I would note that there was 0 requests to the discovery referee to resolve this issue if it had existed prior to trial. And I would finally note that the documents that we're talking about, and this may frustrate the court, and I apologize for that, none of these documents have been marked as an exhibit by any party to this case for this trial.
So hold on, I can't write as fast as you're talking, so bear with me. Okay.
So we're arguing over documents that this jury will never see. We haven't offered them for evidence. The plaintiffs haven't offered them for evidence. And I'll respond immediately as to the plaintiff's counter argument to that, which is, oh, well, we didn't know what was in there. We couldn't find it, whatever. That's not accurate. And we tried in our opposition to this motion to walk the court through exactly what happened. And again, you know, when you go second, it's a little bit frustrating when the argument starts in the middle rather than the beginning. There are 2 categories of documents here. There are documents that were retrieved from both the Mesa and the Henderson facility, and those documents are hard copies, paper copies. And then there were computer related materials. I'm using that as a very, very generic term. So there was some personal PDAs, there were some phones, there were hard drives loose, there was a hard drive that had copied things off the internet. There were various, I'm going to call them computer devices in the very largest sense of the word.
So in other words, ESI.
ESI, Your Honor, 100%, and you probably know where I'm going with this. There was a request by the plaintiffs that we prioritize how this stuff gets produced. We had records going back even pre-2014. And so the production of the documents occurred on a rolling basis after the bankruptcy was lifted and after the documents were transported from Arizona to Nevada. And we set forth that in my affidavit. And in fact, plaintiffs were present when not only the documents arrived, but boxes containing these I'm calling them computers again, these electronic devices arrived. All of those materials, everything was sent to Hollow. And we've provided pictures, and I go through this in paragraph 9 of my affidavit, pictures of, here's what it looked like when it got here. Very frustrating, but plaintiffs skipped paragraph 11. Paragraph 11 of my affidavit, if we could zoom in on that, please.
Yeah, I even underlined it when I was reviewing.
And we meant what we said there. These materials, the paper materials, the computer devices were produced before the Gallagher trial. The Gallagher trial happened in October of 2023. That was, I think, when the verdict was. I think we started pretrial motions. Boy, it went on for a while. In June or something like that. So what we're talking about is we had gone in, we had Hollow at a great cost. It was approximately, just for the electronic stuff, $50,000 to $100,000 to get that stuff retrieved and put in a format that was usable. And that happened in 2022 and 2023. As you can see, we attached our 20th notice of compliance. There were 19 before that. If plaintiffs wanted to build a timeline as to when specific documents were disclosed, they certainly could do that. My recollection, for whatever it's worth, is there was a priority with certain things. I believe they wanted the QuickBooks data first, and then, because they were looking to see where materials were purchased and that sort of thing. But all of this stuff, for lack of a better word, was produced prior to the Gallagher trial. And then on paragraph 15, I talk about, the QuickBooks data, which was saved from the cloud by Blaine Jones. That was very important because at the time, plaintiffs were looking to make sure they had the right parties to the case who provided materials, the ORC meters, and so forth. Generally, and this is in paragraph 17, all the documents produced from the electronic devices were produced on a rolling basis with the, I would say, least important, for lack of a better word, stuff produced into 2023 prior to the Gallagher trial. As the court's aware, and as we've said in paragraph 18, there's nearly 300,000 pages of stuff here. And so when plaintiff pulls out, an email that wasn't attached to their motion, what I meant when I said that I hadn't seen it, wasn't attached to their motion, you can reach into the magic hat and pull out, a document out of the 300,000 documents. And yes, I haven't seen it. Maybe I saw it at some point, who knows? And there's so much stuff. So when I first spoke to Mr. Parker, and this is in paragraph 20 of my affidavit, on March 4th, he expressed concern after the last trial that not all the documents had been produced because there was 2 or 4 total documents out of this 300 pages of stuff that so far we have not found. Could be in there, frankly, we don't know. And so I explained to Mr. Parker that we had done 2 things to make sure that the materials were produced. On January 4th of 2024, the plaintiffs requested, and we agreed, that they could have copies of these hard drives. Again, for lack of a better word, they could have the electronic data. And plaintiff's affidavit from Ms. Gates talks about how difficult it is to access that stuff.
So you all can take a little comfort, or maybe not comfort, but I know what ESI is, and I know something about it.
Thank you, Your Honor. But that's not all we did. We then reached out to plaintiffs, and what I would like to do, JP, is I'd like you to pull up, do you have the appendix handy? I would like you to pull up, let's see, Exhibit I, please. And the first page of Exhibit I is my response to Mr. Parker after the meet and confer, where I explained to Mr. Parker, because he wasn't part of the discussion, that after the Hunwertson trial, we had reached out to the plaintiff's counsel, Brianna Switzler and Eric Pepperman, and said, look, in the Hunwertson trial, there were some emails that we saw that we haven't seen. We don't know if they're there or not. So we're going to run a new search on the data that was previously searched. And that's at the bottom of the first page. And we give a category of our search terms. Anthony Randolph, Milwaukee, Hannah, Costco, Speedy Mart, Nevada Beverage, and NSF. So these are additional search terms that were run on the electronic data in addition to the search terms that were run in 2023 and 22.
Okay.
And we invited plaintiff, if you have additional search terms, provide them to us and we'll have Hollow run it. And as plaintiffs in their affidavit point out, you have to have a search term, or you have to have some idea as to how you're going to get this stuff. So we ran those search terms, and I told Mr. Parker we were going to run those search terms, and we had another meet and confer. And I believe this is on
page 7.
Yeah, this is on Exhibit K. We pull up Exhibit K. I'm sorry, it was actually J, wasn't it? JP, you were right. Jay had I attached my email from January, I was talking to Mr. Parker, said, look, here's what previously happened. Here's how we searched this stuff again in February. And oh, by the way, we're going to search again, and it's going to take a while. And Ms. Gates agrees that it takes a while to do these searches, and it was another, I don't know, $20,000 or so. So this stuff has been searched twice, produced technically 3 times. And with 300,000 pages of materials, there's a lot of duplication. There's no way for us to know how many times something has been produced, because every time you run a search, it's going to pull up everything related to that search. Now, we all, the real water litigants, I'm going to use that very loosely, in Exhibit N, if you pull up Exhibit N from me, please. Recognize that this was a problem. And as a Nancy, in our appendix. There we go.
So now we're going back to summer 23, right?
That's right, Your Honor. And you'll see that Mr. Dodrill proposed revisiting an ESI protocol at the special master hearing in 2023. And at the time, plaintiffs rejected and said, we don't need an ESI protocol. Clearly, we kind of do. It's a little late now. But to go back to, the sort of the why we're here and the problem, really, unfortunately, the buck stops with counsel me. And I was trying to communicate this, apparently not very effectively, to Mr. Parker, because nothing has been withheld. Mr. Parker said that stuff has been withheld, destroyed, or not disclosed. And that's not true. The stuff has been disclosed. Nothing has been withheld. We're unaware of anything being destroyed. Inviting somebody to find 4 emails out of 300,000 pages of documents that are electronically filed is an impossible task. All you can do is your best to try and find things. And then I think, the only other concern, I want to make sure that I nail all of these. You know, we said multiple times in our opposition that these materials had been previously searched and produced. And the new search, as Ms. Gage points out, and as the court has acknowledged, it's a very time-consuming, complicated process. We had to hire an outside vendor to, that's what I want to talk about, to code these documents. And this is where I think the meet and confer has failed, because plaintiffs have raised for the first time today the document type in the index. And they've said, look, when we look at the index, we can't find what we're looking for. Had we had a meet and confer on that issue, I would have explained exactly how that document type came to exist.
Let me, I'm gonna kind of switch you on gears. So part of your argument is talking about, you know, hard drives, etc., these storage devices that contain the ESI. And I think you said, you know, we agreed to provide actual copies of like the hard drives to plaintiffs.
Yes.
Is that correct? And I don't know if you said, or you may have, or you may have implied, but you did provide those to plaintiffs.
We did, and it was in Ms. Gates' declaration that she received them on January 8th.
Okay, and that was, so you answered follow-up question. I thought it would have been in January. And then the documents that are identified in the 589 page index, correct me if I'm wrong, those are documents from the ESI that was shared in essentially kind of a native format in January. Is that right?
Partially, yes.
So when you say partially, what do you mean?
It was previously searched in 2022 and 23 and produced in 23 and 22 as part of the Gallagher case. The new search, if you will, was to search the same data set, but with new terms in February.
And so this data set is and I may be getting things wrong, but is it part of what you gave the plaintiffs in native format in January, or are we talking something that came from somewhere else?
No, it's exactly as the code would be for, you know, a production of documents. They are in the ordinary course of business. That's how these documents came to Hollow, and that's how those documents were presented to the plaintiffs. The plaintiffs said they can't search them, and that may be true of their law firm, but I know for a fact that Hollow could search them, or another vendor could search them. It's just not, you can't just, for lack of a word, Google in it. You've got to have.
No, again, I'm fairly familiar with the sides. So I totally interrupted you.
No, and I appreciate that, Your Honor. I appreciate the question. So again, the documents were presented to the plaintiffs in the same manner in the ordinary course of business as Real Water kept them at the time of the bankruptcy. And everything that Real Water has digitally, the plaintiffs have digitally. They just have to have a tech company, tech savvy person like Hollow access them.
Part of why you offered back in January, February, whenever it was, hey, we're going to be running search terms. Here's the terms we want to run. Do you want to run any? And you didn't get a response.
That's correct, Your Honor. And then finally, what I would add is the index itself. The index, you know, it's the saying in the industry is garbage in, garbage out. It's only as good as the information you put into it. And so in trying to figure out how to organize these things for an index, we had a general category: emails, letters, fax, text messages, emails regarding hydrazine, and I think it probably is cut off. And so the fact that plaintiffs were able to, you know, reach into the 300,000 pages of stuff and find something that the description is not ideal is not surprising to me. And again, I think that if we had had a meet and confer on that very issue, I could have explained, look, you know, when we came up with how to create a index for this case, we knew nothing about the case. This was, you know, probably 266,000 documents ago.
So it looks, I think I see what you're saying. So under the document type column, and we could just look at, well, actually there's several on there. There's more than one, so there's several that say emails / letters / fax / text message. So that's like a category of the documents.
That's correct. And somebody,
and there's other categories like the top one, emails with Polycon regarding bottles, or the second one that Mr. Parker focused on, emails regarding hydrazine. Those are essentially, I think, were they like, well, I guess I don't know, but are they auto-generated those, or is somebody inputting those categories? Do you know? Or
yeah, my understanding, Your Honor, is that they are pulled out of the document if possible, and then when the person reviews the document to make sure there's not a social security number or a phone number, they try to correct it if the auto pull was mistaken. And in this case, I can only speculate as to why the word hydrazine is in there. Somebody was probably afraid to delete it if it was computer generated. They're probably afraid that, oh, look, if I delete this word, maybe I'm hiding something. So the fact that the document turned out to be innocuous, it is what it is. It's just, you know, there's so much that you have to have the computer pull the data into a usable format when you create an index, and you do your best to try and make sure the index is usable. I mean, in this case, it is usable because it's clearly an email from Jeffrey Dosatello, who's a witness in the case. You can run a word search and find that. And I think the other thing that maybe Mr. Parker misspoke was he said that this was the first time they got an index, and maybe he just meant as to these documents.
I think that's the way I took it.
Okay, because we provided an index for all whatever number we're up
to. Yeah,
whether
he said or not, that's clearly how I took it. So that's not an issue.
So we would say that, you know, there has, under the Bahina case, under the Johnny Riviero case, there's been no effort to conceal. There's been no effort to destroy things. There's been no effort to hide things. In fact, I'll be very candid with the court. And plaintiffs asked if they could have the same, I don't know, what's the word, textbook to work off of that we're working off of, or in this case, the data set of computer files. I was thrilled. Hey, yes, our client's bankrupt. You want to run your own searches? You don't believe we're finding things? That's fine. You run your own searches. They didn't do that. And, you know, I don't know why they didn't do that. But I think that Ms. Gates' affidavit really supports what we said in our original meet and confer on March 4th, which is there's a lot of stuff here. This is going to take a lot of time for us to go through, and it did. We ran the searches in late February. And it took all of March to get this stuff produced again. But, unfortunately, there's not a good way for us to say, of these 16,000 pages, what is duplicative of before? Because frankly, we want to be overly cautious. We want to produce things. If we produce them twice, there's no harm. If we don't produce something that's critical, absolutely we recognize there's harm. So these documents were reviewed and produced in 2022, 2023 on a rolling basis, all before the Gallagher trial. And when I say documents, I'm talking generic.
You're totally repeating yourself.
I apologize.
That's
trying
okay.
to sum up.
That's okay.
If the court has any other questions, and again, I apologize. We try, Mr. Parker and I speak practically every day. And we tried to meet and confer and make this issue easy for the court, but I don't think we did. And I apologize for that.
That's okay. Thank you very much. $10 minutes.
Thank you. Thank you. That's fine. What I thought you were going to do. But I'll take it. I'll take it back.
You're very good. You're very good. Yeah.
Thank you. You don't count the setup, do you?
Say that.
You don't count the setting up.
Oh,
It's done. I think there is some agreement here. Let me say that.
Okay.
Mr. Odou, maybe this was unwittingly done, but Mr. Odou did not contest that there were documents that we discovered in the last trial that have not been produced, or at least not been identified by Real Water as a part of its production. And we've looked, we spent a lot of time trying to find them. But if Mr. Odou is correct, and I believe him, and they did a search using Mr. Randolph's name, then those documents should have been produced. And it wasn't just 2 or 3 pages, Your Honor. There were dozens of pages that Real Water should have produced that included either Real Water, Drink Real Water, Randolph, Amy Jones, Brent Jones. Those names were riddled in the documents that were produced during the Hunwartson trial, during trial. Now, we didn't bring a motion against Real Water in that case like this, because I wanted to give Mr. Odou time to figure this out for us. And he's correct. We had a lot of conversations and we've tried our best. And to the extent that we have been, our motion practice doesn't seem to be completely on point in terms of what my motion is and what his opposition is, Your Honor. We both apologize for that. But I can tell you it was not for lack of trying. Your Honor, we should not have to do the defendant's 16.1 production. And a plaintiff shouldn't have to spend $20,000 per search to make the defendant produce documents that are relevant to the case. Rule 16.1 requires that without us asking for it. Now, Mr. Odou said that we produced it in the manner in which it was kept by Real Water. Well, that's not true. It was produced to Holo in boxes, and then Holo did whatever it did. And it made it difficult for Mr. Odou's firm, because he, using his words, and I'm writing this down as he was speaking, he said he started that search in February, which makes sense, February of this year, because that's when the trial was going on and things were happening. And it took him all the way until April 1 to give it to us. Your Honor, there's no way in the world we had 2 months to start from April 1st and be ready for trial. It was impossible. 2 months would put us already into June. All of May, all of April, and all of May. We would be starting trial using his timeline. It is impossible for us to catch up. And that's despite all the conversations we had. So Mr. Odou, and like I said, I consider Mr. Odou a friend, and I take him at his word. Hopefully he does the same with me. But I will tell you, using his own arguments, support our position that some relief should be afforded to plaintiffs. Because if everything he said is right, then those documents and those searches should have been done in 2021, 22, 23, and produced so that we could actually use them when we took his client's depositions, when we took the depositions of third parties. Because I will tell you, Your Honor, Mr. Odou doesn't contest this. The documents we found with Terrible Hurts, which was a retailer, Your Honor. Also,
no, I think you could hopefully rely on the fact that I've grown up here, et cetera, et cetera. I know what terrible.
Absolutely. Absolutely, Your Honor. Also implicated the distributors, Your Honor, Nevada Beverage. And if we had those types of documents that Mr. Randolph was giving to that retailer, then where's the comparable ones to Costco, the Whole Foods, the Speedy Mart, to those distributors? Your Honor, we don't see them in these reductions. And from what Mr. Randolph has said, and what we've learned, he was marketing throughout the valley. And certainly we know that Costco was selling the product, Whole Foods was selling the product. Your Honor, we don't see those documents. So, Your Honor, there's no way of reconciling what Mr. Odou said when you look at paragraph 11 of his affidavit, when you look at page 12 of his brief. His opposition said those documents were produced until the end of 2023. The trial in Gallagher, we had 5 weeks of arguing motion practice, Your Honor, and then the trial started September 5th. So if he produced at the end of December, Your Honor, we either were in trial, because the trial didn't get finished until October, or was after trial. And then we would have started this process for Hunwardson. So, Your Honor, the cost that we've spent just trying to figure out what should have been produced 3 years ago in the form of an appropriate 16.1 was not done. And perhaps it prejudiced Mr. Odou's defense, but that's not our cross to bear. We have been hamstrung by this, Your Honor, and Mr. Odou has said nothing to deflate those concerns or to confirm to you that they comply with 16.1, because they didn't. And the only other thing I would say, Your Honor, because Mr. Odou brought this up, thank God he did. He said that this could have been something just dealt with in front of the special master. So I was glad he did that, because it brought full circle what I said earlier. Your Honor, there's several special master hearings that discuss this, and Exhibit 9 to his brief doesn't say that the plaintiff didn't want the documents, but no plaintiff should be, I would say, way burdened with having to spend $20,000 per search, still not to find the documents. Because if they did it correctly, and let's just give Mr. Odou, defer to him, give him the deference that they did it correctly, they should have found documents that they still have not produced. Real Water has still not produced the documents that we found by Terribles. We still don't see the comparable documents from the other retailers or distributors, Sean. So documents have been withheld. I'm not saying intentionally, but we don't have them. Documents were provided late. Mr. Odou has confirmed that. He said his own search took 2 months starting in February to April 1st. And we didn't get access. When I say access, just because you give us the safety deposit box, if we don't have the combination, that's not access. Just because you give us the vault and we don't have a key or the combination, that's not access. And that's not what 16.1 says. You have to give us the documents. We have to be able to review them, and we have to be able to use them, Your Honor. And we weren't. Plain and simple. Thank you, Your Honor.
Thank you very much. So I'm going to be a little scattered in reasoning. So when the order gets prepared, you'll have to clean it up some. But so the plaintiff's motion to strike Real Water's answer on order shortening time is denied. And Mr. Odou, you'll prepare this order. This isn't a motion to eliminate, it's a motion to strike, and your prevailing so prepare it, submit it to Mr. Parker for review and approval. So I'm going to go through a lot of reasons, and they're going to be kind of scattershot, so I apologize. But one of the issues that I raised a few times, especially during opening argument, you know, we need to have substantive, on point, good faith, meet and confer effort under EDCR 2.34, and in a case like this especially, that needs to be detailed, and that has not been met here by plaintiff, especially as set forth in plaintiff's motion. The motion, as pointed out, lacked, I would say, detail, lacked essential material facts, many of which are supplied in the opposition, some of which supplied here at oral argument by plaintiffs, some of which supplied here at oral argument by the defense. But there's a reason why we have 2.34. And so this is a discovery issue, and 2.34 certainly applies. You know, some of the material presented today, you all have trial coming up, so I'm not inclined to, you know, defer ruling or anything like that. And so when we're confronted with material that's not in the motion or reply, it you know, puts both the opposing party and me as the judge who's ruling at a disadvantage. And yes, sometimes that can be okay, but the general rule is it's got to be in the motion, and here a lot not being in the motion goes to part of the totality of circumstances where plaintiff has not met, plaintiffs, plural, I guess, have not met their burden of showing that any sanctions should issue at this time against Real Water, whether it's as requested in the motion and as confirmed in the reply, the drastic, and I'll use that word, drastic sanction of striking their answer, and even hasn't met the burden under, you know, a irrebuttable presumption, instruction, and fees and costs sanction. So the court considers totality of circumstances. You know, when I was preparing previously, you know, and re-preparing again, one thing that stood out to me, and again goes a little bit to what I was talking about, how it makes it difficult for the other side and for me as the judge when you don't put this stuff in your briefs. So one thing that stood out to me was, like, here's plaintiff asking for the, you know, yeah, it's not case terminating sanction, but striking answers, the drastic request for relief. Normally, maybe I'm emphasizing that too much, but quite often, put it that way, quite often these types of motions will have alternative relief set forth in them, where the movement understands, hey, I know I'm asking for a lot, but so judge, if you're not inclined to grant this, here's why you should grant, you know, a presumption instruction or a negligent instruction. Didn't have that in either the motion or reply, which lends some procedural support for denying the motion, especially in a case like this where I'm hearing, you know, scores, I guess, of motions. It's important to be detailed and thorough up front. The court denies it for essentially all the reasons. Also, I'm not going to read through them, but in the opposition, so if I skip over anything, you're going to make this order super detailed. But applying, the tests and factors set forth in the applicable cases, those being, Young versus Ribeiro, Lahina, Foster versus Dingwall, all those cases, plaintiff hasn't met its burden, the plaintiffs haven't met their burden. Let's see. It's, going to one of my significant plaintiff not attaching, documents to the motion, not having raised this issue in front of the discovery referee or special master before. The, hindsight 2020, but it's significant to the ESI protocol was proposed, was, trying to think of how we would characterize it. Whether you call it rejected or not agreed to, or for whatever reason, proposed back in the summer of 2023 and ended up not being agreed to and not having performed. That's a big factor in a case like this here. The plaintiff's argument wasn't that necessarily that things have been intentionally destroyed or withheld. But even plaintiff's argument that, negligently not produced or negligently withheld, or there's a reason why generally in cases like this, you'll agree, well, maybe you all don't, but quite often in cases like this, it's important to upfront come up with an ESI protocol, come up with search terms. It is significant, where, okay, as of January 24, from the information I have, the ESI provided in what I would call native format or native copies of January 24 provided to plaintiffs. That's significant. Search terms proposed, not responded to earlier this year as well. So with and put this in the order, with the large caveat that goes back to some of the procedural issues I've already talked about, but with the large caveat that, yeah, right now I have one page of a 589 page index that was mentioned and gone over in one document out of 16,000 documents, and a newly produced declaration by Kelly Gates. I would have preferred to have all that type of stuff up front. It wasn't up front, so the court does consider it, but with the caveat that it's difficult, if not possible, for the court to thoroughly address it. But to the extent I am considering, which I do, it doesn't show, it doesn't support granting the motion either. It's understandable that there may be a category that may have in this category, I'm particularly referring to emails regarding hydrazine or hydrazine, sorry. Bates 266-472 to 266-474. That from the court's review, which again is limited given how it was put in front of me today, appears to be a categorization of that particular, or those particular pages of an email chain. It's not uncommon where you're dealing with tens of thousands, if not hundreds of thousands of pages of documents where either an automated type of code or a human place code out of tens of thousands, hundreds of thousands ends up not matching the document. That doesn't give good cause for any type of sanction. Yeah, so he's saying, at the end of the day, plaintiffs have not met their burden of showing that any type of sanction, whether striking an answer or giving there's two types of instructions, and this goes back to, this alternative relief, not even in the motion, otherwise I'd be reading it out loud right now, but neither type of instruction is warranted at this time. That of course is subject to, we'll see what happens at trial and the like, because we'll have hopefully general set of proposed instructions, but it's not uncommon where we need to tweak those or add one or two or whatever at the end of the trial based on the evidence. So that's the order.
Thank you, Your Honor. Is that denied without prejudice, is what you're saying, Your Honor?
Yeah.
Perfect. Thank you, Your Honor.
Yeah, no, you're welcome. Anything else while we're all here?
I don't have anything else, Your Honor. I don't know if anyone else does.
Your Honor, trilogy for the real water defendants. We had a question that spoke to Mr. Parker about this as well. Some courts.
You might need to have somebody sit in your conversations between the two of you guys.
Yeah, we're a pair. I will grant that. And apologize again.
That's okay.
We talk practically every day.
That's okay.
We were talking about voir dire and questions that the court would ask the jury, and some judges just want that. Other judges want all of our voir dire. We wanted to get the court's inclination on that.
So I apologize, because as you were talking, I was thinking of what you were asking, and repeat your question.
Sure, Your Honor. Some judges like us to have listed not only the voir dire we're requesting the court conduct of the prospective jury, but the voir dire that we are as parties going to conduct. Other judges are just asking for, hey, if you want me to ask a question and everybody agrees, give it to me in advance. And I wasn't sure on that continuum where the court falls.
Yeah. So the easy part of that is if you all agree that you want me to ask any particular question or questions, give that to me in advance, like on the 23rd maybe, and I'm happy to ask that. That's easy. If you all agree on particular questions, I'm happy to ask them. And then was part of your question what you all want to ask? Or
yes, Your
Honor. So generally, under the rule, you're exchanging proposed questions amongst yourselves. Questions / people have asked me, am I super particular on, hey, if this question's not written down in your exchange, am I going to exclude you from asking it? Generally, no. Categories is, usually fine. if there are in between now and the 23rd, if there are questions or areas that you all have some disagreement on, particular ones, I'd be happy to get those from you, and I generally have, practice, and those are pretty easy to rule on if I have something even the day or the day of in advance.
Generally, we do categories.
Okay, yeah.
Most attorneys take it. You can't just give, Mr. Hager would have it. Yeah.
Well, and the judge would too, because
Right.
they'd have, yeah.
So we do categories.
Okay.
I would point out that we have done this twice before. So
Yeah.
I don't think there's a lot of new questionnaires. So I would rather just do
That's fine. Yeah.
The categories is fine with us too, Your Honor. We just didn't want to run afoul of the court. We have done this before, and some judges appreciated the way we did it. Some judges had questions about the way we did it, and so I just wanted to get out in front of it and make sure that we're not running afoul of the court's rules.
Yeah.
We got past Judge Kishner with categories.
We did it.
that's probably a good sign, right?
Your Honor, if I could just add.
Sure.
The categories were what we submitted to Judge Kishner. If there's something you want, or if there's something specific for us to submit to you, that's one thing. If it's just to exchange amongst ourselves, we could work together.
Yeah, I don't need really anything from you all. The caveats would be, if there's an area that you all have a disagreement on, it's easier for me, as I kind of emphasized already today. If you want my input to rule on it, give me something beforehand. Like I said, with this stuff, the issues are quite common. But if you do, to reiterate, if you do want me to read any particular ones, have at least a draft for me to take a look at on the 23rd. I do go like through general, well, let me back up a little. You all have questions. I almost forgot. Amanda would beat me over the head right now, given that she's had to deal with them, but I almost forgot you all have questionnaires. So a lot, hopefully a lot of what I would generally ask at the beginning is already in those. But if you have ones you want me to ask that are not repetitive of the questionnaires, just get those to me and be happy to ask.
I understand everything you said, Your Honor. The one caveat I would bring up is with the questionnaire. Sometimes the questions that are asked, the response is, hey, I do have a hardship, but there's a question of, is that a real hardship, or is it, something that they should be excused or not? So we don't intend to re-ask the questions, but sometimes you need to because of that dispute. But at a minimum, the questionnaires narrow the number of responses to that who are questionable. We've stipulated to a lot that are very clear, and some don't even put a hardship. And then there's that other category they say they have a hardship, but we think it requires a little more inquiry to be able to evaluate.
And I know there's not very many, but I know there's been, I don't know, a handful or so that I've already quote unquote ruled on that. But yeah, like you're noting, sometimes you'll have answers on any of the questions in the questionnaires that aren't sufficient for you to say this person needs to be excused, but they may certainly require some follow-up. I totally understand that. Does that answer your?
It does, Your Honor. I just had one last question.
Sure.
If the court can give us a preview, I know we're coming back for a formal calendar call, but a preview on ruling on objections outside the presence. Does this court have any special rules? Will bench conferences be reported, or do we need to excuse the jury to have a record?
That's a good question. So the bench conferences up here are recorded. I sometimes, like the other day, I had a criminal and they were saying things, and I reminded the attorneys, hey, don't forget, when this light's on, it's being recorded. So that's the good news. Unlike when I was on the third floor and the courtroom was so small, we had to do them off. They weren't being recorded, but here bench conferences are recorded. My practice generally is if you have an issue that makes you nervous to raise in front of the jury, it's probably a good idea to come up here and ask me. May we approach? I'm compared to what I've heard, I haven't really sat in other judges' trials, but I'm fairly lenient in terms of I'd rather have you if you are concerned. Probably our right to be concerned. May we approach?
Thank you.
Come up here and we'll put the white noise on. Standard type of, the one word type of objections, that's a different story. Make them from the table and give me your 1 or 2 word response and I'll rule on those. But yeah, if it's something that requires some discussion and is likely something the jury shouldn't hear, may we approach? And if it gets complex, then we take a break. Since I'm talking, one of my pet peeves, don't waste jurors' time. And so if there's things we need to talk about outside their presence, we're going to have to meet before I bring them in for the morning, or after they're excused, that type of stuff, or on the lunch break. I don't like them sitting in the hall waiting for us. And anything else while we're talking?
Thank you, Aaron.
Okay, so I'll see you on the 23rd, right?
Sounds good, John. Thank you.
Thank you all.
Thanks, Your Honor.